Hello everyone, my name is Dezu Chen and I am a paralegal at Oakland Solicitors. Today, I am excited to guide you through the key concepts of FOB contracts, a cornerstone in international trade law. In my presentation, I will include 1. What FOB contracts are. 2. How risk transfer in these contracts. 3. The responsibility of both buyer and the seller. 4. What remedies are available for breaches, with the example from case law and legal legislation. Let me start with a question. What are FOB contracts? FOB, or Free on Board, is a common international trade agreement. Under this contract, the seller must ensure the goods are delivered to a specified port and loaded onto a shipping vessel. Once loaded, the risk and ownership transfer to the buyer. The legal framework for FOB contract is established by the Sale of the Goods Act 1979, SOGA, and international trade rules such as Incoterms 2020, ICC rules. Let's move to risk transfer. One definite feature of FOB contracts is how risk transfers. General rule, the risk passes to the buyer once the goods cross the ship's rail. Exceptions, later vessel nomination by the buyer, can delay risk transfer and give the rise to the seller remedies. Next is the key case studies. Let's solidify these principles with 2 landmark cases. 1. Pirate Company sued Cynthia Steam Navigation Company, 1954. The court clarified that in FOB contracts, risk transfer to the goods close to the ship's rail, even if the disputes are real with the carrier. This established the importance of risk timing in such agreements. Here is another case. Bungie Dax Export SA, 1981. The buyer delayed nominating a vessel, breaching the contract. The seller was awarded damages. This case highlights the buyer's obligation to fulfill their duties, avoid liability. Let's move to duties of parties. FOB contracts clearly outline the responsibility of both the seller and the buyer. The seller's duties. Under a classical FOB contract, we can see 5 main obligations. 1. Shipped goods as specified in the contract. The seller must ensure that the goods match the description in the contract. 2. The seller is responsible for all costs up to the port, including handling and transportation. 3. The seller must ensure goods are shipped on time at the port of the shipment. 4. The seller also must notify the buyer of the shipment in a timely manner, enabling to the buyer to arrange insurance. 5. In most cases, obtain an export license. Under a classical FOB contract, the buyer also has two key responsibilities. First, the buyer should secure shipping space by arranging and communicating vital details to the seller in time. Second, the buyer should make a payment for the goods, which is typically due once the goods pass the ship's rail. Now move to remedies available. Sales remedies. Under a classical FOB contract, if the buyer breaches the contract, the seller has the right to take action for the price. If the property in the goods has passed to the buyer, but the payment has not been made. Second, damages for non-acceptance. The seller may claim the damages if the buyer wrongfully refuses to accept the goods. Other remedies include the right to a lien on the goods until payment, stoppage in transit, and the right of resale, particularly if the buyer becomes insolvent. Now move to the buyer's remedies. Under a classical FOB contract, if the seller breaches the contract, the buyer may 1. Reject the goods when the seller has not title to the goods or the goods do not match the contract and the quality. 2. The buyer may claim the damages for the defective goods or non-delivery. 3. Sue for non-performance if the seller fails to fulfill their obligations. However, there are limits on rejection. The buyer cannot reject the goods if the breach is so minor that it would be unreasonable to do so. To sum up, FOB contracts are widely adopted due to their clear rules for risk transfer, balanced responsibility for both seller and the buyer, and effective remedies for breaches. They also enhance trust, reduce uncertainties, and promote efficiency in global trading. By understanding these principles and learning from case studies, businesses can safeguard their interests and ensure smooth global transactions. Thank you for your attention. And if you have any questions, I will happy to answer any question.